Major news out of the state of Delaware. In the case of Jennings versus Rigby, a major case involving so-called ghost guns, we have a submission here submitted by the Department of Justice of the state of Delaware arguing why they have a right to take away our right to make guns for ourselves under the Second Amendment. You're not going to want to miss this episode when we come right on back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner and constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We'd appreciate the support. All right, folks, here's the story. As I've taught you before, wars are won by winning a series of battles. So sometimes we have to get into the geeky little battles that go on in these court cases so you understand what's going on in the process. Because sometimes, for example, to draw an analogy to football, you need a series of 3-yard runs before you can break off the big play and win the big game. Okay, so here's what I want to talk about today. I want to talk about a pending case brought by the Firearms Policy Coalition called Rigby versus Jennings. It's pending in the United States District Court for the District of Delaware. That's right, Joe Biden's home state of Delaware. So far, the plaintiffs in this case have accomplished quite a bit, and it's been a tremendous success. The law they challenged was the Delaware state so-called ghost gun law that basically makes it impossible and illegal to make your own firearms. Now, this law was enacted, and after NYSERPA versus Bruen was decided by the U.S. Supreme Court, there was a lawsuit brought by the Firearms Policy Coalition and other plaintiffs, and they claim that there is no historical analog to justify the banning of making your own firearms. Now, the good news is the federal judge in this case, I want to make sure I pronounce this correctly, Mary Ellen Noriega, entered an order in favor of the 2A plaintiffs. In September of 2022, and we covered it on this channel, Judge Noriega said that the right of the people to keep and bear arms requires that, by necessary implication, that we have the right to acquire those arms. Because no matter how much you like guns, when we're born as a baby, we obviously don't have firearms. At some point in our lives, to exercise our right to keep and bear arms under the Second Amendment, we have to be able to acquire those firearms. Well, by necessity, someone's going to have to make those firearms, which means that somehow we have to have the right for firearms to be made. Now, whether or not someone makes those firearms for us, like a gun company that sells them to us, that's fine. Or we make them ourselves, a do-it-yourself firearm. Well, that is exactly what the judge found in her entering a preliminary injunction enjoining this ghost gun law, again, which is a euphemism for banning guns that you make yourself, do-it-yourself guns. So in September 2022, she entered an injunction saying that under the Second Amendment, we have a right to acquire guns by necessity. Otherwise, there's no way to exercise the right to keep and bear arms if we don't, first and foremost, acquire them. And by extension, we have the right to make our own guns because nothing requires someone make the guns for us. So we have the right to have guns, and therefore we have the right to make guns, which I think makes a tremendous amount of sense. And she applied the Bruen standard correctly. The first step, as you know, is you look at the plain text, and the text of the right to keep and bear arms implies by necessity the right to acquire them, which by implication means that you have the right to make your own guns because you have the right to acquire them in various ways, including making your own guns. So she said under the plain text it's protected. Then she looked to see were there any historical analogs at the time of the founding that restricted or otherwise banned or governed in any respect the right to make your own firearms. And of course, in 1791 and during the time of our founding, not only was there no restrictions on making your own firearms, people were encouraged to make their own firearms. Because remember, at the time of the Revolution and during our founding, we were very nervous. Even after we won the American Revolution, we really had a second world war, if you will, in the War of 1812 against the Brits. So our founding fathers were always worried about fighting off foreign influence and foreign invaders who wanted to take our country from us, including Great Britain, that wanted the country back. So there was always a concern among the founding fathers that we had a domestic firearms industry and that we had access to arms. So obviously there was no disincentive. There's only incentives for people to make their own firearms in all sorts of ways because the founding fathers wanted us to have more and more guns to protect our new country against, among others, British invasions, and so on and so on. So obviously Judge Noriega made an excellent finding here, the correct decision here, But now let's talk about what's been going on lately and what is the breaking news. Well, there's a submission in court by the Department of Justice. It was actually a joint submission by both the plaintiffs and the Department of Justice. So what did the state of Delaware's Department of Justice argue? That's right, the state of Delaware's Department of Justice argue. Well, they've submitted a letter here alongside the plaintiffs saying that they want a lot of discovery. But that's simply absurd. And we've talked about some of this before. So what they really want, what they're saying in this letter, and I'll post it down below, is that the Delaware state lawyers say they need probably until sometime in 2024 to figure out this case, to justify their case, and to prove what they need to prove to win the case. Now, the plaintiffs are rightly arguing that that's not needed. They make a series of points, all of which I think are quite persuasive. The first point is there's no need for any factual discovery of the parties because the essential facts are largely not in dispute, which is that these plaintiffs want to be able to make their own firearms and that you have a law in place that says they can't make their own firearms. So that is really all you need to know. Once you show that the plaintiffs are law-abiding citizens, they're not criminals, they're allowed to have firearms under 18 U.S.C. 922G and so on and so on. Very basic stuff. There's nothing complicated there. I don't think there's any dispute. The plaintiffs are, good, upstanding Americans and allowed to have guns in all respects. So there's no debate on that front. So really the whole focus is on, is this state of Delaware law constitutional under the Second Amendment and under NYSERPA versus Bruen? So that's the standard. Now, what the government obviously is doing is they make several points here. The state of Delaware argues that they want to have expert testimony. But again, what's the purpose of that? We've talked about this in other videos. The expert testimony, presumably, that the state of Delaware wants to advance is historians. But as you know from the Heller case, there was no testimony in the Heller case. There was no hearing in the Heller case. There was no trial in the Heller case. There were no expert testimony in the Heller case. The Heller case was able to find the legal standard was if a firearm is in common use by Americans for lawful purposes under the law of the Second Amendment, then it is protected, and that handguns are ubiquitous, meaning they're everywhere. They're in common possession by Americans for lawful purposes. Therefore, they're protected. Again, no trial, no big fights. All of these were based on what's known as legislative facts, which the plaintiffs talk about here, which are simply kind of facts that are understood about the world that we don't need to have a trial on or a dispute over. For example, we know that Joe Biden is the president. Donald Trump was the prior president. Barack Obama was the president before that. You don't need to have a trial and introduce evidence on these basic facts. We know that, for example, gravity pulls things toward the center of the earth. Again, you don't need to have trials on this evidence. We know the weather in a particular place, in a particular part of town, in a particular state yesterday. These are the sorts of things you don't need evidence on. You don't need a trial on. There's no dispute. So basically, the Second Amendment plaintiffs here are saying that there's no dispute that the anti-gun Delaware people have banned the right to make firearms for themselves, and that we want to make guns, and that all you have to do is interpret the Second Amendment as applied, as interpreted by the U.S. Supreme Court. There's no need for discovery, there's no need for experts, and there's no need for historians because, there were no historians involved in the Heller case. Yes, some of them submitted amicus briefs, but at the end of the day, remember, keep in mind, historians have two jobs. The first is to go find the history. The second job is to present the history. But here, and this is the key point I want to make about this, when Delaware enacted this so-called ghost gun law, right, which I think was in October 2021, the law of the land was already the Second Amendment, and the law of the land was already the Heller case that was enacted in, the Supreme Court issued their opinion in 2008. So the state of Delaware had many years to look at and analyze the Second Amendment's text and to read the Heller decision and to understand the in common use test, and so on and so on. So Delaware, by enacting this law through legislators that had sworn an oath to uphold the United States Constitution as well as the state constitution, had already vouched that these laws were constitutional. They had already looked at the text, the history, and tradition, because remember, the text, history, and tradition test is not new to Bruen. The text, history, and tradition test, including the in common use test, all can be found in the year of our Lord 2008 in Heller. So why is it that Delaware comes to court today in 2023 arguing that they need all this time to figure out whether or not the law they enacted, the same people that swore an oath to uphold the Constitution enacted this law, why do they need all this time to justify and prove the law is constitutional? Didn't the state of Delaware do this work already? Right? They passed the law. The same people that passed the law had sworn an oath to uphold the Constitution. So they presumably have already done the homework to show that the law was constitutional. And if they didn't do the homework, then shame on them. That's their fault. They don't get to spend another year of our lives trying to justify an unconstitutional law. So it seems to me that the judge here, if I were the judge, I'd say, like, look, you passed the law. Presumably you passed the law assuming, having done the homework that was constitutional. If you didn't do the good job and you didn't do your homework in, well, then too darn bad. But I'm not going to give you time to, after the fact, try to justify this arguably unconstitutional law. So whatever you figured out at the time you enacted it, give it to me. I'll take a look at it. And again, we don't need any discovery. We don't need any experts. We don't need any testimony. We don't need any trial. Because if the Supreme Court doesn't need all that stuff to decide the Heller case, and the Supreme Court doesn't need all that stuff to decide Catano, and the Supreme Court didn't need a trial or anything like that to decide Bruen. Remember, Bruen was decided on a motion to dismiss, which meant that the Bruen plaintiffs sued in New York State Court. The defendants, meaning the state of New York, filed a motion to dismiss saying, assuming everything the plaintiffs say is true, it doesn't matter. There's no claim under the Second Amendment because they don't have a right to carry guns outside the home for self-defense or any other purposes under the Second Amendment. The lower court dismissed the case saying, yeah, you have no Second Amendment right to carry. It goes all the way up to the Supreme Court, and the Supreme Court decided Bruen quite clearly. So why can't the federal district court judge in Delaware do the exact same thing the Supreme Court did in Bruen, that the Supreme Court did in Catano, and the Supreme Court did in Heller, which decide the constitutionality of the statute under the Second Amendment without the need for a trial, experts or historians, or so on and so on and so on. So it seems to me that the state of Delaware is probably trying to drag their feet and delay the inevitable, which is they're going to lose this case. Because as you know, in September 2020, this same judge already found that the plaintiffs are likely to prevail on the Second Amendment. So, maybe the judge will change their mind, but I'm guessing it's probably not likely. So to me, Delaware is just trying to delay the inevitable. As far as I'm concerned, they should file their briefs, they should make their arguments, and let the judge rule, and then take an appeal. Either side can take an appeal to the extent they're unhappy with it, but I don't see the need for a bunch of discovery. But that is exactly what the state of Delaware is asking for in this case of Rigby versus Jennings.
Orders up. Table 2A.